Alright, I don't know if you guys remember this video from last year. It was in Balboa Park, I believe June 5th. Ranger, the ranger in the middle, I'm not going to mention his name, but this ranger here in the middle had been violating a bubble performer's First Amendment rights, and I was trying to speak up for the bubble performer. Um, the ranger told me a couple of times that if I continued to speak, he was going to get me with disorderly conduct. At this point, the bubble performer says, this isn't going to stop me from doing what I do. I'll be back. And I said, good. You should never let bullies intimidate you. And that's when the ranger stops, looks me directly in the eyes, and says, you're being detained for disorderly conduct. Um, I bring up this video and what happened because after a year later, I went to court, lost in the traffic court, was found guilty and convicted of this disorderly conduct. I then hired attorney Michelle McKenzie, and she appealed my case and brought it before the Superior Court of San Diego. And the trial judges have just sent back their response in the trial. I'm going to read that response, but I would like to do a little recap and let you see the moment where Ranger Danger here decided to give me a disorderly conduct ticket and violate my First Amendment rights. Good. Don't let them intimidate you. They're being bullies. They're being bullies. Oh, yeah? I'm not interfering. He was talking to me. I was responding. I'm being detained for what? I didn't hear. Okay, your attitude is getting out of hand, sir. I want the police here. I want the police here now. Call the police, please. Call them, please. I want him arrested for deprivation of rights under color law. Cassidy, you heard me. I want him arrested for deprivation of rights under color law. As you can see, none of the rangers took what I said serious. All these rangers were complacent in deprivation of rights under color law. These rangers all violated my rights. They all said that they all agreed and acted out on behalf of this ranger back here, whose name I shall not name for other reasons. But if you want to see the full video, it's Ranger Danger. The saga continues. I'm going to pull up the court case now so that you guys can see the decision or the statement of reasons by the court. William Joseph Dorsett versus the people of the state of California. Appeal from September 7th, 2023. Judgment following bench trial entered by the Superior Court, San Diego County, Peter W. Singer, Commissioner. This matter was scheduled for argument and taken under submission on March 27th, 2024. Reversed and remanded. On June 25th, 2023, appellant received a citation from San Diego Park Ranger issuing a citation for a violation of San Diego Municipal Code 56.27, disorderly or offensive conduct in public places. Appellant received the citation for criticizing and video recording the ranger as he issued a citation to a different individual. Appellant challenged the citation, and after a bench trial on September 7, 2023, he was found guilty. He filed a timely notice of appeal. Appellant argues that his conduct was free speech protected by the First Amendment to the Constitution of the United States. He further argues that the San Diego Municipal Code 56.27 is unconstitutionally overbroad and that the trial court erred by using an incorrect definition of disturbance when deciding this case. The people concede appellant's conduct was free speech protected by the First Amendment and was not a violation of San Diego Municipal Code 56.27 and therefore submits without objection. Following de novo review, we conclude that the appellant's conduct was protected by the First Amendment of the Constitution. The freedom to speak without risking arrest is one of the principal characteristics by which we distinguish a free nation. City of Houston, Texas v. Hill, 1987, 482 U.S. 451, 463. The judgment of conviction must therefore be reversed. In light of this conclusion, we need not address whether this conduct would otherwise violate Municipal Code 56.27. This matter is remanded to the trial court to dismiss the conviction and to conduct any necessary further proceedings consistent with this decision. Albert T. Harutanian III, Presiding Judge, Appellant Division. Marianne D. Adazio, Judge, Appellant Division. And then Burchak J. concurring. I concur with the majority's decision to reverse and remand this case based on the appellant's conduct being constitutionally protected free speech. Given the similarities between San Diego Municipal Code 56.27 and the ordinance in City of Houston, Texas versus Hill, 1987, 482 U.S. 451, it appears that Municipal Code Section 56.27 should be declared unconstitutional on its face as well. In City of Houston, the United States Supreme Court found that the ordinance was unconstitutional. That ordinance was, it shall be unlawful for any person to assault, strike, in any manner oppose, molest, abuse, or interrupt any policeman in the execution of his duty, or any person summoned to aid in making an arrest. ID at 455, Citing Code of Ordinances, City of Houston, Texas, 34-11A, 1984. The court found that the ordinance was not narrowly tailored to prohibit only disorderly conduct or fighting words, and therefore distinct from other cases where related ordinances had been upheld. ID at 465. They also found it criminalized a substantial amount of protected speech. ID at 466. And part of the reason they chose to reach a determination that the ordinance was facially unconstitutional was the ordinance could not be limited by severing district unconstitutional subjections for the rest. For example, it cannot be limited to core criminal conduct such as physical assaults or fighting words because those applications are preempted by state law. See Supra at 2510 and N10. The enforceable portion of this ordinance is a general prohibition of speech that simply has no core of constitutionality, unprotected expression to which might be limited. ID at 468. As City of Houston, the ordinance here is very broad, arguably significantly broader than in City of Houston. The municipal code at issue reads, that it shall be and hereby declared to be unlawful for any person to be guilty of any offensive or disorderly conduct in or upon any of the streets, alleyways, sidewalks, squares, parks, or in any store or other public place in said city, and it shall be unlawful for any person to make any loud noise or disturbance or use any loud, noisy, boisterous, vulgar, or indecent language on any of the streets, alleys, sidewalks, square, park, or in any store or other public place in said city. San Diego Municipal Code Section 56.27 similarly to City of Houston is not narrowly tailored to prohibit only disorderly conduct or fighting words. While it prohibits disorderly conduct, it also prohibits offensive conduct and loud, boisterous, and noisy language. The breath then criminalizes a substantial amount of protected speech, and like in City of Houston, that potentially unprotected speech and conduct it prohibits is preempted by California statutes. Municipalities' authority to make ordinances and regulations is governed under California Constitution. A county or city may make and enforce within its limits all local police, sanitary, and other ordinances and regulations not in conflict with general laws. A conflict exists if the logical legislation duplicates, contradicts, or enters an area fully occupied by general law, either expressively or in legislative implication. Sherwin-Williams Company versus City of Los Angeles, 1993, 4 Cal 4th 893, 897. If an ordinance is purposed to prohibit acts which are made criminal by the penal code, it is clear they exceeded the proper limits of supplementary regulation and must be held invalid in conflict with the statutes and within which they duplicate. In Portnoy, 1942, 21 CLA, 2D 237, 240. There is a specific Penal Code section regarding disorderly conduct, Penal Code section 647, and it relates to loud disturbances, etc. The legislated enacted Penal Code section 415 to address the unprotected speech. Both statutes had clear extensive litigation related to where the constitutionality permitted line is for restrictions on speech. For example, the California Supreme Court has found there are constitutionally limits on criminalizing noise, holding when the word noise in the statute is properly construed consistent with the First Amendment and traditional values. It encompasses communications made in a loud manner only when there is a clear and present danger of violence or when the communication is not intended as such but is merely a guise to disrupt persons. In Brown 1973, 9 Cal. 3D 612, 619, under Brown, the portion of this ordinance criminalizing loud, boisterous, and noisy language would clearly be unconstitutional unless it were limited to language demonstrating a clear and present danger of violence or when it is intended to disturb. If it is limited to these circumstances, then the language is covered under Penal Code section 415 and the ordinance is preempted. Because of this extreme overbreadth and issue of preemption, Municipal Code section 56.27 is unconstitutional on its face. I concur in reversing judgment and remanding this matter to the trial court. Frank L. Bruichak, Judge Appellant Division. And then it just has the William J. Dorsett versus the people of the state of California, and Clerk of Superior Court M. Figueroa signed it. Directed to Michelle McKenzie and Mara W. Elliott. And that is the appellant court case for my disorderly conduct citation given by the ranger last year in Balboa Park. This has been the update for Ranger Danger. The saga continues. I will further update you as news develops. Have a great day, local buskers and artists.